Until the enforcement and enactment of the Real Estate Act, there was, like we all know, no real law governing real estate sector in India. Right. Now, for the first time, the authorities are making it mandatory under the Real Estate Act to submit the legal documentation to the authority regarding the properties. So I'll come to Rule 14 of the rules that have been notified recently in October, specifically talking of the Chandigarh rules, which applies to all union territories. And in that, there is Rule 14, subclause E, subclause 2, and capital subclause E. Now, here it says that at the time of registration, you have to provide a certain amount of legal documents. In those documents, there are various requirements of a title search report, a due diligence report. And then in clause E, it says that where the promoter is not the owner of the land. So a joint development agreement or a development agreement, the need for it arises when, say, Amartya, you have a piece of land. Let's say you have about 1 acre of land, and I intend to construct on it. And this becomes very important later at the stage of payment of stamp duty also. That if I'm not the owner of the land and I decide to construct on it, what rights will belong to you as the landowner and what rights will belong to me as the person constructing, because the land is yours, the money is mine, right? You are not putting in money and I don't have the land. So that is, I mean, contractually speaking, the consideration there is this reciprocity. So now clause E says that you have to give the details of the collaboration agreement, development agreement, joint development agreement, or any other agreement as the case may be, entered into between the promoter and the owner, and copies of title and other documents regarding the land proposed to be developed. So now, for the first time, there is a statutory requirement of having proper, well-documented, well-drafted joint development or development agreements. Until today, what had happened was that various states used to do various things. In, let's say, for example, South, in Andhra Pradesh, you were allowed to execute what is called a development agreement, cum GPA, which is a development agreement with a general power of attorney. And the stamp duty there was different. In some states like Maharashtra, where there was a Real Estate Act, you were not allowed to do that. Or you were allowed to do that with some modifications. Things like that. But there was no requirement of actually the intending buyer, which is the person who purchases the flat. He would never actually know what the development agreement says. As a purchaser or as a buyer, you would only execute what is called a builder-buyer agreement. Or like after your allotment letter, whatever agreement you sign with the builder. For the first time now, this becomes important that the consumers or the buyers will also know what the development agreement is. And the relevance of this specifically is that I can now independently verify the title of the property. And this becomes extremely important because there are various amounts of frauds happening wherein the flats are built and then you realize that the land was never belonging to the owner in the first place. So not only is the developer or the builder in a problem, but you as a prospective purchaser are also in a problem. So that essentially is why we're talking about the joint development agreement.